why don't we do this? Why don't we take like 3 to 5 minutes apiece, and just kind of give us your, the LawCash sort of elevator speech and the Legalist elevator speech, some vital statistics about your companies, how long you've been around, how big a company you are, what kind of services you provide. And here, I will flip this packet of mayonnaise and pretend it's a coin. And heads, it's LawCash, and tails, it's Legalist. Ready? It's heads. LawCash, you go first.
All right, perfect.
And I'm gonna eat. I'm gonna eat while we're doing this. Please don't take. I know that's very unprofessional, but I'm starving. So
no offense taken at all in any way, shape, or form. So
no, in a quick way, do you want to talk about the ethics of litigation funding, or just generally about the company?
Well, I'm gonna. That was one of my questions for you. So we will be getting to that, right? So okay. I wrote down about 10 things that I'm really curious about, that I'm sure my fellow litigators are also curious about. So I'll be getting to that, but feel free to get into it if you'd like. I'll defer to you.
Okay.
Perfect. Well, Harvey, I was just going to introduce you. I mean, you started this whole thing. You're a pioneer in the industry. You were knocking on doors, trying to really get this thing started back 20 years ago when it first came to America. And so really I think you're the best to hear from of how this got all started. You formed Alpha, where that's, the American Legal Finance Association, which makes a lot of the standards that a lot of the other companies are following in the industry. So go ahead, Harvey.
No, I appreciate it. Thanks so much, Frederick. Thank you, everybody. Frederick's right. We been in this business for 22 years, roughly. Just to give you a little bit of my background, I started off just general credit over the years. We did healthcare financing, and one of the financing in healthcare was funding individuals, some of the doctors, and some of those doctors had liens that were owed to them by lawyers. And we started looking at that and realized that could be a potential business. And we put our toe in the water in 1998 and formally jumped in 2000. And we've been funding ever since, starting with our own capital and then growing from there. So LawCash makes advances to people who've been injured in accidents while they're waiting for their case to settle. There are different types of litigation funding, and maybe Kurt and Robbie would talk about different ones, namely the attorney or law firm lending. There's also commercial lending when you're going to go on one particular case and finance that. But we're set in the pre-settlement funding world, which is making advances to individuals. So before I get into that, LawCash has grown. As I said, we're one of the largest in the United States. We've funded in excess of $600 million since we started. We have grown to the point that last year, it's been just a year, where we sold the business to a group of institutional investors, set up a new entity called Legal Business Services. Legal Business Services owns LawCash. I'm the chairman of Legal Business Services. And what that did is institutional money behind us. We have a net worth in excess of $200 million. We have funded cases all across the United States, both in the pre-settlement side. Also, we do funding for law firms, small law firms. We go from the $500,000 up to the $2 million range in what our scope is. I was one of the original founders of Esquire Bank, which is a bank for lawyers, by lawyers that we set up in 2006. Esquire Bank is now a public vehicle that can make lines of credits available to lawyers, up to the $20, $25 million range. So we have a whole gamut of opportunities. And as Frederick said, along the way, as we started this business, there were a lot of unscrupulous people in there. And a lot of it centered in Ohio. There was a group that were making advances to people, charging 180% per annum. And they could do that because the definition of litigation funding, it's not a loan. A loan has to have an absolute some certainty of repayment. If you don't repay because you can't pay, that's not it. But in our contracts, if you lose your case, you do not owe us the money. It takes away that absolute some certainty, and that's why we can charge what we can charge. But there were companies charging, in excess of 180% per annum. We were able to fight those. There was a negative case in Ohio called the Rankman, RANCHMAN case, where one of these companies gave somebody $5,000, and a year later it grew to $25,000. It became a big case, went as far as to the Ohio Supreme Court. And we jumped in as part of our new trade association, argued that it's not usurious because it's not a loan. And we won. And they did fine for the Mrs. Rankman, saying instead of being usurious, it was champernous. And that was a great precedent. What I was very pleased with over the years of continually working with the trade association in 2007, I believe, we came back and got a law passed in the state of Ohio where now it overruled every other thing in Ohio. It is legal to do funding in the state. So in 2004, we set up the American Legal Finance Association, which was a group of companies designed to protect ourselves from unscrupulous other lenders. And it was set up in a way that, why would you deal with somebody who was going to be deceptive and charge high rates? Why don't you deal with a company who stands in the light of day and does things the right way? And we started with 3 companies. It's grown from the 3 to 46 companies. I was the founder and chairman for the first 14 years, and now I'm chairman emeritus of that organization. But I'm sorry?
I'm sorry to interrupt.
That's okay.
Yeah, I've got a million questions, and I'm going to try to pare them down to like 10. And Christy, and Melanie and Dominica, I bet have some more. But before we get to those, I want to give Robbie and Kurt a chance to talk about their company a little bit, and then we're going to start firing inane questions away at you. So let's do that. So Robbie, Kurt, give us the high level brief history and sort of the vitals about Legalist.
Sure, no, absolutely. So my name's Kurt Smoller. I guess I'll jump in. I'm a lawyer. I've been practicing for about 24 years. I was a partner at Fox Rothschild in the San Francisco office. I did general commercial litigation. I was a trial lawyer. I also started my own law firm. I had started with one lawyer in my living room, not unlike what I'm doing, where I am kind of right now. And I grew it to about 10 attorneys. I then sold that to a law firm, and then eventually made my way to Fox Rothschild. I was in trial when a friend of mine said, "You gotta meet these 2 amazing, Harvard people." And so I went over to SOMA in the middle of the trial, and they told me about what they're doing with algorithms and basically what they're doing with computers and AI, and I was blown away. And maybe it was the fatigue of being in trial for 6 months on the same case, but I was just like, I'm totally in. This is great. So I went over, and there was 2 people there when I started. I was the 3rd person. We basically, what we have is we focus on smaller cases, similar to what Harvey was just talking about, which is basically $500 to $2 million dollar cases. So in the past 2 years, we've made 175 investments sorry, 175 cases, 100 investments. We've raised over $100 million in the past 2 years, I believe. We've grown from 2 people to over almost, I think, 20 at this point. We are in, I think, every major market. We fund mostly commercial cases. Uh, we have some other civil rights cases that we've been involved in, some police shootings, some other things that are kind of sort of timely and kind of involved in what's going on today in society. Uh, we are basically, and I've written articles about this in the ACC. What our focus is sort of is shifting the risk, is shifting risk. Really, when you're looking at cases, I think lawyers look at this as just, you know, the legal part. They're not looking at the financial situation and how the fact that you can actually adjust the risk from yourself and your law firm onto a third party who takes it on a non-recourse basis and then basically run your case as if you normally would and have the ability to profit from that case and be able to run your law firm. When I had my own law firm and I had, you know, I had a line of credit, which I never called on, but it was terrible. It was much worse, where basically if I got in debt for it, I had to pay it back, regardless of anything, regardless of whether my law firm went out of business, regardless of whether I lost my key client, regardless of anything. And, you know, and basically this has been, and I've represented banks and huge companies when I had my own firm. I had a very successful small firm. Basically, the way I look at this is really kind of an evolution of law. The idea is that lawyers are very good at what they do. They're very good at litigating cases, and that's what I love doing, is going out and finding great lawyers to do good cases that they ordinarily might not do because of the fact that they don't have the money. The billable hour, nobody wants to pay the rates. I think, $900 an hour or something like that when I was at Fox, or something like that. That was my rack rate, I think. I don't even remember. It's like getting foggy. I'm getting old. I'm sorry, but that's how I was a lot of money. And now the question is that really a rational model? If I have if I have a large client and they have small matters, are they going to pay me $100,000 to go after 2? No. Are they going to give me, basically the idea is that if I want all the business from my good clients, you have to be flexible and you have to look at things as hybrids. You have to look at things as more, lawyers have to evolve here. They're not from my perspective, the Supreme Court did say it's a business a long time ago. And because it's a business, not everybody can do everything. So again, I see it as a shifting of risk. I see it as the ability of, we have 65% of the AmLaw 100 firms we're funding in at this point. And, this has all happened in a relatively short amount of time. I attribute that to the market. I attribute that to the fact that we have a tremendous technology behind us, to be fair. And I think that it's really, you're looking at a fundamental shift in the business of law. And that's my spiel.
So let me ask, from a mechanics standpoint, a logistics standpoint, right? So I have a law firm, the Gertsburg law firm. I have, it's about half litigation, half transactional. It's all business, right? If I have a case that I want to take on, but it does not make financial sense for me to do it, right? Whether because it's speculative or because it just will require more labor and funding than I'm prepared to put into this case. I go to cash pay, to LawCash, or I go to Legalist. Walk me through what I can expect my experience to look like from the moment that I'm explaining the case to you until the case is really completed and funds are paid out. Why don't we start with Legalist? Robbie, Kurt, what does it look like from the lawyer's perspective?
So from the lawyer's perspective, we actually look at it as it's similar to any other sort of experience that you'll have with a company. What happens is that it's sort of a dichotomy. What you have on one hand is you will have a dedicated investment manager. You'll have somebody who works directly with you and talks to you about your case. They will sort of, talk you through what's going to happen. Then what will happen is that you will go through diligence. When you go through diligence, that usually means that it used to be just me. I was like the only person for a long time who talked to everyone. I went through thousands of cases. But basically, now what happens is that you'll talk to a lawyer. The lawyer will basically, talk to you about your case, go through the fundamentals, basically make sure that all four pillars of a case are there, basically that there's liability, damages, the duration, and collectability, right? Because those are kind of the things that, every case has, or should have if we're going to be investing. Then what will happen is that you will, if that lawyer thinks that the case is a good case, because that one of the biggest, and I'm sure that this is something that LawCash will appreciate. At the beginning, everybody thought this was going to increase bad lawsuits, and that makes no sense whatsoever from our perspective. Because why would we possibly invest in bad cases? We are in the bit we're non-recourse funding. If you don't win, we just lose our money. So the idea that somehow we're going to invest in a bad case is, doesn't make sense. But anyway, that was a tangent. But the point is that we have to basically go through the fundamentals. Then, if the fundamentals are solid, we will term sheet the case. The case will, when you get the term sheet, it'll be the basic terms of what we're looking at. As we briefly talked about, this is different than a loan, and so often it's an investment. And what you'll do is that you'll get the term sheet, and we'll have somebody talk you through the term sheet because of the fact that it is different than what you would have in a traditional loan. If that's signed, if you say, hey, this is a great deal, sign it, get it back to us. We go through diligence. We go through underwriting, sorry. Underwriting takes about 2 weeks. We come out with an LFA if the case checks out. It takes about 2 weeks. You get the LFA, and we negotiate that. You sign it, and funding starts. That's the 30,000-foot view of us. Yeah.
Yeah, and our side, we have two vehicles for it. One is, I mentioned Esquire Bank, which is a regular commercial bank that you'd have to go through their due diligence. That would be more for a traditional line of credit as opposed to a one case. If you're calling on a one case, they won't do it. We have another entity called ARDEC, ARDEC Funding. They're in Long Island. They'll do as low as a couple 100,000 up to a couple million. But what they'll do is talk you through it, understand what the case you're talking about. One of the things you said earlier, Alex, we don't want to get in a case that you think is marginal, but hey, you're going to risk our money on it, so let's take a shot. We, believe me, have seen that before, and what we want to know is this is a great case. You have other cases that you're putting up as collateral if that case doesn't work, but that you think it's there, save the money that you'd have to spend. And particularly, we have a lot of people with med mal type cases where there's heavy expenditures. We'll do that. But our doc does shorter term. You need money right away. They'll get it to you in 2 or 3 days by talking through things, starting off small, maybe, less than a couple 100,000, and then working from there. Esquire Bank, traditional bank, longer term time, but very, very low rates.
And the analogy I'm thinking of is like a construction loan, right? Where there are draws, like we send you the time and then you reimburse us for the time. Is that how it works?
Yeah. Kurt, you want to go first?
Yeah, sure. I mean, it's up to you. I mean, I'm fine either way.
That's okay.
It depends. The answer is, unfortunately, it's a lawyer's answer, is that it depends, right? So there are different kinds of structures. There are situations where there's, one cash draw. There are, the majority of how we look at it, though, is similar to a construction loan. I did a lot of litigation on those, but yes, it's like a construction loan. Basically what happens is that you bill, we have to get the client's sign off on it, because it's otherwise that you're just because of the I think the lawyer's sort of concerns, we don't want to just be approving bills, but the client approves it, it comes to us, and we make payments. And it's based usually on a approved upper limit.
Right. So and that makes sense. There's some sort of budget that the parties agree on ahead of time. You don't want the lawyers going completely sideways on time, or at least it's planned out. And then at the end, I presume then there is well, you guys, and I'm assuming that there isn't a one size fits all here. So
that's where, Alex, just to jump in for a second, as I said, Esquire Bank would do lines of credit. So you would be looking for a line that would be, encompassing all your practice, or so you can utilize it as you need it. Where our deck funding is much more case specific, you can get on the phone, go over things, and go through, as Kurt mentioned too, the budget, where you're going to put out, I need X dollars today, and then but keep giving me updates, and you're talking to them real time. You're talking to the guy that runs it, and he'll give you that okay and get the money to you within a couple of days. So
can you give me an idea, ballpark? And again, understanding that different cases have different metrics and numbers, but give me an idea, sort of generically, what would I, as a litigator, expect to see in terms of financial terms for my case, for the payouts, for the fee sharing between me and your two companies? Whoever wants to go first, jump in.
Are you talking about the lawyer funding only, or are you talking about the client funding?
I guess both. I mean, so what I'm imagining is a situation where I have a contingency fee case, okay, and the lawyers are getting paid some amount through your companies as I go, and then the client gets paid by the success fee, the contingency at the end, right? So is that can you just give me some idea about what the shares, the fee splits are? What should the lawyer expect to see per hour? What should the client expect to see in terms of the split between what they get to keep and what you get to keep? And does the lawyer get to keep any piece of that at the end as well?
Yeah, I mean, I can talk to you on the client side, on the LawCash side. Basically, it's a straightforward deal. You need $1,000. There's depending on the type of case, it varies between 2 to 3% per month that exists on that, and it all is contingent upon the success of the case. For example, a motor vehicle accident has less worry than a medical mal, so they're varied with that. But I'll just say the average is around 2.5% per month, and nothing happens if the case takes 1.5 to 2 years. Everything sits. There's no monthly interest. There's no anything. When the case settles, we expect, because we have a lien on that case, when you're dispersing money, the way that would work, the paid proceeds, so to be, would be attorney fee first, attorney cost first, second, any kind of medical liens or other liens third, and the pre-settlement funding company gets paid, and then the balance goes to the client. That's basically how that works.
I'm sorry, the 2.5 to 3% per month, that is money that LawCash is paying to the client?
No. In other words, the client needs $1,000 or $2,000, and the cost of that money is anywhere between 2.5 to 2 to 3% a month. But nothing is paid until the end. But when the case settles, we get paid. The biggest thing you have to understand with this is over 70% of what we use the money for, what we give clients money for, is to stop an eviction or a foreclosure. Most of our clients are people, they're normal people, they're not indigent people. They're normal people that get caught into a situation where they were working, now they're on disability, they can't make ends meet, they fall behind, and then they're faced with a terrible thing. Do I tell my lawyer, settle a case now because I'm desperate, I'm going to lose my house in a month, or find some other alternative? And you know, if you go to an insurance company in a time of weakness, they're going to try to give you a low ball amount. So what companies like LawCash do is provide the money just to get over that hump, and then let them wait until the lawyer does his job, not ask for more, but just what he should have gotten if the case went to its normal term.
So LawCash's only real return, for lack of a better word, is it just that 2.5% to 3% per month?
Yeah, they get nothing. That has nothing to do with the value of the case. If you hit for a $10 million verdict, all LawCash would say, you took out $1,000 on September 16th, and then September 1st of 2021, the case settled. You just pay that different,
So you're not advancing attorney's fees to the attorney. You're advancing just funds to the client.
Well, there's two things. That's where I was asking you. This is the LawCash side, which does life needs. If we were advancing money to you, as I said, under Esquire Bank, it wouldn't be on a specific, it would be on the whole line of credit based on the value of your firm. We'll look at all your firm's collateral.
Got it. Okay. Legalist, how about you guys? Is it pretty similar?
It's similar. We tend to do we tend to not fund plaintiffs as much for the sort of things that LawCash does. We tend to do more commercial fund cases. So what you'll have is that you'll have again, it's in the $200 to $1 million range of funding, but it's usually what we look at is a number of different things. You can have portfolios, which are similar to what we were talking, LawCash was discussing with Esquire Bank. So you'll have entire, groups of cases. You can have individual cases. Ours is not really dissimilar. It's just, I would say it in a different way, which is, although we don't do a percent, we don't do it on an interest rate, we do it on a multiple. So basically it goes to, if you have a case that is successful, that we fund and it's successful, we get a return of between 1 and 4x of whatever we put in, regardless of the basically that's regardless of how high your return is. There are other ways we've done it, which involve percentages of the recovery, but we don't really do that. We did that when I first started. I don't think we really do that anymore. It's mostly just a multiple of the amount that you are getting funded, that's committed, and that's pretty much it. I think there was another question that went to control, but that's, I think, a separate question. So I didn't know.
Well, okay. So, let's go there. So, obviously, you guys are almost like an insurance company as it relates to the questions of privilege and representation and engagement, right? The attorneys have one client, or however many they have, and it ain't you, right? It's so they have a fiduciary duty, duty of confidentiality, a duty of loyalty, et cetera. And I'm sure the courts have spoken to this. But so I guess the first question is, how much visibility do you have into the attorney-client relationship, and then secondly, Kurt, to as you were anticipating, how much control, how much say do you guys have in how the case is managed?
Okay, so I guess I'll jump in, but basically, the top 3 questions I get from lawyers are privilege, control, and I mean, those are pretty much the top 2 that I get. Like, basically, it's, how do you deal with the issues of privilege, and how do you deal with the issues of control of the case? I'll take the second one first, mostly because, so I litigated cases for a long time. I have no interest in litigating your case. None. Okay. I've been there. I've answered interrogatories. I am not there. Right. So, I'm not, I don't want to be in a discovery dispute over, emails. That's my least favorite thing. That said, Our control issue really is a financial one. In other words, we do influence the case in certain ways. In other words, before we get involved, I'm very clear about this. I'm like, look, we're putting money into this case. The way in which we are going to be having influence on your case is the fact that we are going to be recovering a certain amount of money if you win, right? So that changes the dynamic. In terms, that is really how we quote control. It's not an overt control. It's the fact that you now have the fact that there's money involved that isn't, that basically has to be recovered by an investor. So it's similar to if you're working at for a company that gets an investment by a VC, they're looking for a certain recovery. That's really how we have control. It's not control. It's just we have a financial interest in the result.
Is it safe to say that you have influence over how money is spent, but not on how strategy or tactics are employed? Would that be a fair distinction?
I think kind of. We're not really, because again, we don't tell you how to spend your money, but it's something that's there. In other words, it's like the fact that if we go and we do this is going to cost this much, and that's the recovery of the funder is going to be X. So you have to make that. It's a business decision, not a legal decision, right? So it influences the business, but not the case. So that's really what I'm saying. It's like it has nothing to do with the specifics of the case. That is, whether or not you get a certain expert or not. We want you to get get the best expert you can get. We want you to win your case. That is clearly our interest, right? So that we don't influence that part. It's just that we're more of a, it's more of just a pure economic question.
Right.
And I'll echo in on that. On the lawyer funding, law firm lending, as I said, it's a line of credit. So we're taking a lien on your cases, and we have a personal guarantee from you. And we're letting you, given the fact that you've cleared due diligence and we realize that your firm is good and your cases are good, we're letting you, adjudicate them as you see fit. But when the case settles, we need to get the money back and then send it back out to you. We do that. And then on the smaller cases where we're RDEC funding, where it makes it on individual cases, takes 2 or 3 cases as collateral. Same way, all we're doing is saying we're keeping an idea of where the money is. We want to make sure that when you got the money back, before you said, oh, I just need it for a moment on the Jones case, and then the money's gone, we want to know we got paid back, and then we'll loan it back to you. We want to have that ebb and flow relationship. That's the best outcome. And then on the client side, and again, it's an apples and grapefruit type of thing, because the client side is maybe the average size is less than $5,000. We've done 600 million of them, but that's the size of them, as opposed to the lines of credits or the one-off, $1 million, $2 million thing. But we need to get the case paid back.
Let me put a finer point on it. So I want to spend money, or I want to employ a strategy in my case, and I have taken funding from one of your companies, and you don't agree with how I'm managing my case or how I want to spend my money. What does that kind of dispute look like if we can't resolve it?
So
go ahead.
no, I'm not sure. Is the question if you want to take the money and spend it on something that we think doesn't make sense?
Yes.
From my perspective, I mean, I don't know if you want to take this. I don't get involved in that.
Okay.
Yeah. It's usually stuff that's not our thing.
Yeah, I mean, if you want, I mean, the idea, as Harvey was saying, is that basically we're investing in the lawyers, right? We're not investing. This is all about alignment from our perspective. We want to be aligned with you, and we're aligning with good lawyers. And once we're so if we're getting lawyers that we don't think they know what they're doing, they're probably not going to get through. So that's kind of the idea. So it's really a vetting process from our perspective on the front end, kind of like when you get a client and you talk to them and you're like, you're crazy. I'm not getting involved in this case, right? Like with a client, I'm not saying any, client is like that. There's no clients like that. But if there were, you'd be like, no, I'm not getting involved in that case. But, from our perspective, we're not going to invest in a case that is a bad case because we lose our money.
Yeah,
So
just if I could echo what Kurt was saying, and it gets back to your thing earlier. If you were going to try to pick up a case and say, well, let me take a shot on this case, I may win $10 million or I may lose everything. Let these guys put the money up. Kurt and I probably wouldn't do that deal. But at the same time, if you look at it from your perspective, you want to build a relationship with Kurt. You want to build a relationship with me and Fred because of the fact that you spend the time. Now we're going to get to know you. We're going to know your ebb and flow and your potential needs and be there to assist you on it. So we're not going to get into the nuances of strategies and where you spend it, but we're at that point in time, we're pretty comfortable with the collateral that we have and the quality of the firm that we have.
And by the way, Christy or anyone else there that's listening in, feel free to jump in and ask questions. The only other one that really sticks out for me that I think I would like to get a little more clarity on is the types of cases. And Harvey, I understand you guys work more like a line of credit than funding particular cases. So I don't know if this applies to
Well, we do both too. That RDEC funding, that's Esquire Bank does lines of credit. RDEC does more case specific. So
does Legalist and LawCash both do class actions?
I don't know about LawCash. We do.
Yeah.
We do class actions, but we tend to do multiple class actions. We tend not to do one-offs.
Yeah, we don't do them.
You don't do them at all, Harvey?
No.
Okay. And so I think I heard one of you say civil rights cases. Yes.
We do that.
Okay. Well, here, let me just, are there, let's just take you guys one at a time. So Harvey, go down the list. Are there cases that you prefer to handle and are there ones that you just won't touch? And then Kurt, same question to you.
Well, class actions, I mean, we need to do, if we do some of these bigger cases, product liabilities, where there's a personal injury involved, we can do that. And we've done, transvaginal mesh. We've done a lot of different, those type of cases. We've pulled back a little on those because those are binary investments. You either win or you lose. And, want to have our thrust is have a lot of small cases. Now you've got a lot of small cases that aggregate up to $10 to $20 million. But we do, medical mal cases, we do product liability cases, slip and falls, civil rights, all types of cases we're involved in. And in the RDEC side, it's, we look at each one on its individual merits.
How about you, Kurt?
So we don't do patent litigation. We just don't do that. We do most other types of, we do pretty much across the board commercial litigation. If you have commercial cases, that's our sweet spot. That's generally what we focus on. We are involved in some class actions, but again, we tend not to be involved in one class action with a lawyer. We tend to be involved in multiple class actions if they're doing them. We do portfolios of personal injury cases, but mostly we usually funding the attorneys, not the individuals. So that's a difference, between us. So we tend to do more on the, commercial, case contracts that have gone wrong, buildings, construction projects that have gone poorly. We have done, as I mentioned, some police brutality cases we funded. things of that nature. But again, it tends to be more in the commercial space than in the personal injury, but we've done both.
And then again, back on our side, on the individual cases under this our RDEC company, you can talk directly to the attorney, just go through the case, and they'll look at it. And in those cases, rather than a major line of credit, they'll say, okay, that case is worth investing a certain amount, and go through that depending on that. Take a few cases as collateral that are in your portfolio, plus your personal guarantee, and then that could be decided within a few days. So it varies.
Got it. Got it. I'll tell you what, guys, those are the big questions that I had, and I really appreciate that you answered everything that was on my mind. Christy or anyone else that's on with us, do you guys have any questions for any of these guys?
I guess the one question to kind of go back to, so the privilege, so it sounded like it's not like you would need to see it based on the attorney telling you that it's a good case.
Yeah, I mean, you need to see some things like, maybe the bill of particulars or some other thing that justifies what it is, but then the rest of it is talking through it and understanding it, and understanding the nuances of the case in your particular jurisdiction. But that would be about it.
From our perspective, we tend to I mean, we will want to see some documents, and so here there is a case you should look up. It's called Via Media, and that case goes to the confidentiality of the information between a funder and a lawyer. It basically, that case goes through the entire analysis of the attorney work product doctrine, and will basically say how it applies to the funder attorney relationship. So there are times that if the lawyer and the funder will have privileged communications, and that's pretty much settled law from my perspective. Sorry?
One other just quick thing, just to get back to what Christy had said. The ABA did a white paper a number of years ago, and they basically said that, the attorney must, exercise independent judgment. Now, when it particularly comes to the client, it says that they must not waive attorney-client privilege. So, we don't get in the way of that.
Right, and that's exactly where I was going, which is basically, if you go give us information, then that's privilege. It also goes to the fact that if you have a document, and I've heard this multiple times, this document will show that they lose. I'm like, I want to see that document, right? And that's privileged because of the work product doctrine. So basically that's allowed. It's the question, and then so that the privilege is, we make sure, and also we do have non-disclosure agreements, and under the Via Media case, that's required to show that there was no intent to have a waiver of the attorney work product doctrine, which is necessary. So without getting too in the weeds, because in my first year of doing this is like all I talked about with like every single lawyer. They were like, what about the privilege? And I basically became like this like robot of, work product doctrine and attorney-client privilege, and, just going over it over and over. But from our perspective, it's not really going to be an issue. Plus, I mean, bottom line is, it's not relevant. For us to be subpoenaed for your information is not relevant, which it has to be if it's a third-party subpoena, right? And you have the fact that there's not going to be anything bad in there, right? Nothing that they're going to be getting is going to be showing that your case is bad, because if it was, why are we funding it? So it's this idea originally with lawyers that, I'm going to go and get everything that's going to show that they're terrible people and all this stuff. And as this sort of industry has evolved, from my perspective, and I don't have the 20 years, but I have, the 3-4 years, which again is not the same, but it's been showing that, what we're looking at is, we don't want bad cases, and we don't want bad lawyers, and we don't want, if we have bad information, we clearly don't think it's that bad, because we're still funding it. these ideas that this is going to like open the floodgates for information for the client is not really, from my perspective, hasn't come to fruition.
Just to embellish, and there's something what Kurt said earlier, which I'd echo, is on the political side, when I was dealing with different state who were trying to pass laws, they would ask that this maybe sets in motion frivolous lawsuits, or we get in the way of the settlement, or there's nothing left at the end. And what Kurt said earlier is the idea, well, why would we make an advance on a bad case if we're putting the money up, and if you lose, you don't owe us any money back? Or in the case of a lawsuit, why would we go through the idea of having to sue somebody on a personal guarantee? So we look at those things. So we do not promote frivolous lawsuits. We do not get in the way of a settlement. That's between the attorney and the client. And we don't take everything. We were part of a study that was done that showed that with taking an advance on the consumer side, they ended up with getting more ultimately, even with paying out the fees, because it gave the lawyer the time to do the best job that they could and get the fairest, most equitable settlement for their client, as opposed to taking less.
That is a great place to wrap up, guys. Unless Christy, you've got any questions, or Dominica, you've got any questions that haven't been covered, I'm going to wrap this up. Harvey and Frederick, Robbie, Kurt, thank you guys very much. And LawCash and Legalist, I'm sure can find you quite easily on the internet. But we have now your pictures and your names, and so we will hunt you down, and our members will if they need you, and I'm sure they do. I'm sure they will.
Good. Thank you. It was a pleasure meeting everybody.
It's just vodka.
There you go.
Type in vodka and you'll find me.
Frederick, you're everywhere. Yeah.
Thank you guys. Thanks for taking the time.
Thank
Thank
you
you
so
so
much.
much.
My pleasure. Pleasure meeting with all of you.
Thank you. Bye.
Thanks, guys.